The last thing she did before she left the city attorney's office, I understand, was give us the Matt Chason report, which was extremely helpful. Thank you, Jenny. So then the case was transferred over to Todd Ferris from the city attorney's office. So we're on the third attorney here. Todd Ferris refused to do anything and said that he was only on the case for the purpose of receiving documents only. He obtained, I would say against the rules, a stay in discovery and otherwise absolutely did nothing until the Von Briesen law firm was hired. I think Von Briesen had two attorneys who were sort of involved in that with us originally. I don't recall what their names were. They were on the case for about a day or two. Then the bigwigs at Von Briesen decided that they were going to put Jill Hall and Ryan Maloney on this case. So that was another two. Well, I understand that Jill Hall was not up to what was required here, so she left and was off that case. I think some of the documents that she filed and some of the arguments that we'll see here may be linked to that, but I don't know. So she was then replaced by not Ryan Maloney, but Chris Reardon, who I understand, if you go look on his website, is apparently a big deal for Von Briesen. So what do we have now? Peterson, Juan, Ferris, Maloney, Hall, Reardon. So we're on 6 attorneys that I've got. Well, Jill Hall also asserted that she represented Matt Chason, a third-party witness and an employee of MPS, but he is not, as she alleged, a director or a bad actor. He is simply a witness in this case. So they asserted representation over him. I believe that was incorrect. The judge agreed with us, and so Mr. Chason had to get not one but 2 lawyers. He's, of course, not paying for those himself. MPS is paying for those, and they're, for the usual suspects, they're at Buelow Vetter. So that's Mark Olsen and Saveon Grinnell. So I guess we're up to 8 attorneys, and who knows how many else behind the background on Dr. Kuether's case. Dr. Kuether has remained remarkably consistent with her one attorney from Cross Law Firm. But that's usually how things stack up with employee versus employer. I just want to keep in mind that if any of you guys pay taxes to the city, the school district, you are, of course, funding this law firm. They're not, of course, spending their own personal money. Keith Posley is not paying for this loss defense that's benefiting him personally. Neither is Mr. Chason. The taxpayers are. So it's always something to keep in mind. Now, just to back up here in this case, we filed a few requests for discovery. That's one of the few reasons to go to the Equal Rights Division, is because unlike at the EEOC, you're going to get documents, you've got a right for discovery. Well, that only counts insofar as the Equal Rights Division is willing to enforce the laws that it's there to enforce, and part of that is discovery. So, I've experienced plenty of times where employers just simply don't give documents, and you ask for the ALJ to enforce those requests for documents, enforce a discovery, order them to produce the discovery, and I've got colleagues here who are waiting 6, 7, 8 months for even just a response from the ALJ on their request to order them to produce the discovery, but not in this case. Certainly not in this case. There's a near immediate reaction. Certainly there's an immediate reaction when MPS is requesting to have its discovery issues resolved. Not necessarily for the employee, but certainly for the employer, and certainly in this case. So I think it's fair to say, based on my experience, that the reaction time to discovery issues for the employer in this particular case is extraordinary. Okay, so backing up, this is even May of this year, we had requested some documents here from MPS. And the way that works is you serve, meaning you fax or mail copies of requests for production of documents, requests for interrogatories, which are written questions, and requests for admissions, which is these are statements that the opposing side needs to say is either true or false, and explain if they're false, to what extent they're true or not. So we set a full set of documents on them, and what they responded to was no response at all. And for most cases, they asserted that these were confidential, meaning that MPS had a policy not to give out these kind of documents, so therefore it was just going to ignore the laws of the state of Wisconsin. They also said that there was a so-called whistleblower law that shielded these documents, and they made other various arguments along those lines. Well, that didn't work. And I need to just step back here for 1 second and to make clear that Jill Hall asserted that MPS represents, and her law firm represents all employees. Well, why does that matter? Well, first of all, it's not true, and it's not what the law is, so that's important to note. The law firm that represents the employer has a right to understand, and I guess since we're getting into legal information, clearly I'm going to read my disclaimer so that I'm disclaiming that this might necessarily or may not apply to you. So although we are discussing Wisconsin law, the discussion is not intended to be legal advice because it may or may not apply to your facts. Wisconsin law applies whether you understand it or not, so consulting with an attorney is often and only the best way to make informed decisions. Okay. So, we made this request for documents. They said that they represent everybody. Okay, so in fact, they only represent what's called constituents, and that is just a specific legal term here for members of the board, for the CEO, for key members of the organization who actively work with the law firm or the attorneys. Sometimes they'll have a legal department that's actively working with outside counsel. Sometimes there'll be a vice president that's in charge of talking with the attorneys on a regular basis if the president isn't. The so-called bad actor is also one of the constituents. What does that mean? The bad actor is the person who is alleged to have committed the discrimination or created the unsafe environment or something like that. That's what we call the bad actor. And sometimes the direct supervisor, okay? But everybody else there is just a witness. Well, why is that important? Well, everybody has a right to all witnesses' information, okay? That's both the law and the rule for the courts. So I have as equal right to get information out of a witness as anybody else. However, I, as an attorney, cannot talk to a represented party without going through their attorney. So that means if you tell me that you're represented and we have a case that we're working on and I want to come talk to you about settling this case, and you say, Ben, I've got an attorney, well, then I can't talk to you anymore. And that's a similar reason why the police can't talk to you if you assert that you are you have an attorney and you don't want to talk to them anymore because they're agents of the state here. The state has to go through your attorney. So it's very powerful for a lot of different reasons. I think in the criminal context you can understand that, but it's also very powerful in the civil context, what we're talking about here. And what that means in terms of what we're talking about is if I have to go through a constituent, then the employer is going to have the opportunity, the employer's attorney, to filter all that information that's coming from them unless I get them under oath directly in deposition, which is what happened with Matt Chason. When we got him under oath, and you'll see that those videos, we tend to get distinctly different answers than when we ask them, and then they're filtered through the attorney. I mean, I think partly that's obvious, but I think it's clearly not the way it's supposed to be. You're supposed to be getting the truth out of both the attorney and the witness themselves, but here that's not the case. Documents, that's absolutely not the case, and frequently you're going to get a very diluted set of documents here. And that's absolutely what happened here. And I think part of the whole thrust of this story and the whole thrust of what MPS is trying to do is to keep us from getting this information. So, what did we ask for? And why is this so dangerous? Well, let's get into that. We made the following interrogatories that are at issue here. Number 1, for any response to the complainant's first set of requests for admissions that is anything other than an unqualified admission, state why that admission was denied, either in whole or in part, including all facts that support your answer. So we did give them 132 admissions that they had to points about our case that we wanted to know whether they were true or false. So if they said that they were in any way, they denied them in any way, we wanted to know why they denied them, and we wanted to see the facts that made that basis. Well, they didn't really respond to that. Next, we asked them to identify all job duties, the actual work assigned to, and performed by Dr. Kuether between Dr. Kuether's original date of hire and Dr. Kuether's last date of employment. You can tell there's legalese here. It also, we also asked for them to identify and explain in precise detail all communications between Dr. Posley and any MPS employee or member of the school board about the complainant, including who participated in the communication and the nature of the communication. We don't have that. Now, those are the questions we asked. Here's the documents that we asked for. And this is, this is a very short list here. This is not, as you would see, burdensome. The issue isn't the work. The issue is that they're not responding because I believe they don't want to, based on the evidence that I have. So, request number 1. We asked them to provide all reports generated by the NPS Accountability Office for the last 5 years. So that's Matt Chason's office. Give us all the documents for the last 5 years. Number 2, we asked them to produce all documents consulted or referenced in the answering of these admissions or interrogatories. Number 3, provide all communications between Dr. Posley, Dr. Cotton, Calvin Fermin, Dr. Holliday, Matt Chason, Bob Peterson, Tony Baez, Dr. Saffold, Angela Terry, and Adria Magdaleni containing the following keywords. Kuether, C&I, that's curriculum and instruction, whistleblower, curriculum, retaliation, Adobe Flash, literacy, one-to-one, literacy plan, concerns, complaint, Debbie, and Deb. Finally, we asked them to provide all phone logs between Dr. Posley, Dr. Cotton, Calvin Fermin, Dr. Holliday, Dr. Saffold, Angela Terry, and Adria Magdaleni for December 29, 2020. Well, they haven't done that either. Well, we went to the judge and said, Judge, they haven't responded to our requests. Well, what happened? This is in July 25th of 2022. Judge Stephanie Brown ordered, it says, I am granting the complainant's motion to compel as it relates to the complainant's first set of interrogatories and first set of production of documents. If the respondent has not answered to the complainant's first set of interrogatories served on January 30th, the ones I just read, it must do so by August 15th, 2022. So 6.5 months later, they're finally ordered to do what they should have done 5 months before. So that's MPS. So what did they do? They produced 4,000 pages of nothing. I think we went through all 4,000 some pages, and I think we found 5-6 emails that could possibly be responsive, and the vast majority of these were just pages and pages of just nonsense. Thursday folder updates. Here is the distribution list with apparently every email from every employee at MPS I think they give us 3 of these. So we've got, that'll be good for future reference. Again, they gave us 4,000 pages of absolutely nothing. Well, we called them on it. They still didn't produce anything. So we knew from different, both Matt Chason and other sources, that Matt Chason had his own set of offline documents that he keeps. And we decided that we were going to go directly to him and ask him for his version of those documents. Even though we knew that he was being represented by von Buelow at the time. So again, MPS hired an attorney for him, and that attorney represented him and is now saying he should not have to answer those documents. So we understand the setting here. When you ask for documents from MPS and they don't give you the document, there is only one of 2 things that can happen. So you are only allowed to not to give somebody something in discovery if it's privileged. Okay? So that's the first thing. And privilege can usually falls under the category of attorney-client privilege. There's other ones, but that's generally what we're going to talk about. So, but if something's privileged, you don't just not give it to them. What you have to do is have a privilege log, assert privilege. You need to admit the fact that this document exists, but then assert privilege over it, so that you're not giving it to the other side without them then going to the court and saying, court, you have to order them to do that, and we got to figure this issue out. But you don't simply just get to not give it to them. Okay, so that's the first, that's really the only method of things that go outside of discovery. Now, let's say there's something in discovery that you just should not have to give up, okay? Somehow your tax returns are in a set of documents. Somehow there is, gossip, salacious gossip that's really not relevant to this case. There's somebody's, the healthcare record, medical records, other things along those lines that are in there that maybe even are necessary, but shouldn't necessarily be part of the court record and put out there. So what do you need to do with that? Well, in that case, if you have documents like that, the first thing that you should do is go to the other side and say, hey, we've got these kind of documents. We don't think they're appropriate for you to have. We don't want to give them to you. We would like you to agree to a protective order. So protective order is an order of the court where the court says, we are protecting you from having to respond to this discovery for a certain reason. There's only so many reasons, but there is a sort of a catch-all, which is annoyance and embarrassment, and burden. And that doesn't mean that, in theory, that rich people are going to be allowed to hide all their malfeasance. What it means is that if there's information that is potentially embarrassing to somebody but is not related to the case, that could serve as a basis to get that at least not put in front of the case or made public. It may be made available to the other side, but only on a limited basis, and them not being able to publish it or give it to the media or other conditions like that, which that can be certainly reasonable. I have circumstances all the time where the employer wants the straight up tax returns of my clients. Well, there's almost no way we're going to do that, not because we're refusing, but because it's going to be inappropriate, because just for starters, the client's spouse's personal information is going to be all in that document. Their investments, all sorts of other things like that are going to be listed in there, which are not really going to be germane to the issue. What the real issue is how much money did the client make in a given year. right? What is the reported income for mitigation purposes in order to determine what their actual damages are, right? Well, so that really what's sufficient for that is going to be a W-2. If there is more information that's needed, if a client has a more complex tax return, we're certainly willing to provide those documents. But I'm not just going to hand over that kind of personal information because we filed a discrimination lawsuit. So you can see that attitude here where we're saying, hey, there's certain kind of records that are off limit, and that's more by convention. I think there's no hard and fast rule that says that you never have to give up your tax returns. And certainly if any court was ordering me to give up tax returns, we would do it immediately. That's not, the point is that there are classifications of documents that are going to be sort of known ahead of time where we're going to be highly suspicious. And if they're going to ask for them, we're going to say, what is the reason that you want these? And if you want them, we need a protective order because we can't have those out in public. So those are really the sort of the two routes that you can go. Let's say I don't care, I want those documents anyway. I refuse to give you a protective order. Okay, what's going to happen there? Let's just stick with the tax returns issue for a second. What's going to happen is you can go to the judge and say, Judge, I want a protective order for this. The judge is going to come to me if I'm the one refusing and demanding your tax returns and say, why the heck are you bothering me with this? Why couldn't you guys resolve this yourself? And by the way, you probably don't need these tax returns. What the heck? So I don't want to be in that position. Usually the opposing counsel doesn't want to be in that position, and we want to resolve these things, but at the same time, you've got to move forward and try to get this done, and if you need it for your case, you better have a good argument for why you need it for your case, because, everybody knows that those kind of documents are going to be potentially embarrassing or, expose somebody to privacy issues. So with that in mind, those are really the two things that you can do. But if you don't provide any documents, or you don't make that call, or you don't say that these things are privileged, or request a protective order, then it's not just the assumption. It's I guess the assumption in law, but it's not my assumption, is what I'm trying to say, that these documents don't exist. And if they're found to exist later, then you're going to have a big problem because you didn't produce documents that you were required to produce in the course of discovery, and apparently you knowingly withheld them. So, if it was inadvertent, you might have an issue there, but still, there's going to be a lot of costs and fees associated with my time going forward and me having to depose people all over again, ask new questions, have all discovery happen because we didn't have access to the information that we were supposed to have 6-7 months ago. So, the issue that we created there is because we asked MPS and we also asked Mr. Chason, we got the two there. One of them's got to have these documents because we know they exist. So if we ask MPS for all documents generated by this Matt Chason's office, and Matt Chason's running a rogue outfit and he's got them at his house and they're not in an MPS system, okay. Well, that's they want to fire Matt Chason or discipline him. That's up to them. That's not my problem. But Matt Chason's got to have those documents. Well, so it's either or. That's the problem there. So if I get the documents don't get any documents from MPS that are known to exist because Matt Chason told us that they exist, then Matt Chason has to have them. And if he doesn't, then the conclusion that leads me to unescapably is that MPS is withholding documents. So we went to Matt Chason. We asked him for literally the same documents. I won't read those again. I think you can remember what they are. So what happened? First, again, I do want to explain to you that Jill Hall from von Briesen asserted that she represented Mr. Chason in Dr. Garcia-Hoven's case. Well, again, I told her that was not correct, and Judge Brown told her that that was not correct, and in response, MPS hired Buelow Vetter, Saveon Grinnell, and Mark Olsen to represent Mr. Chason. Now, I don't know if we put that up yet, but there's a really great video from that hearing in which Mr. Grinnell, Saveon Grinnell, has really apparently no concept of what he's arguing, but luckily Jill Hall is able to remind him during the hearing. You can sort of hear him say, he's sort of scrambling for an answer, and Jill Hall is able to tell him what to say in front of the judge, and then he says the magic words there, and then we're able to, sort of go forward on that basis. Well, that wasn't fooling us then, and they're sure not fooling us now. There is no daylight between Buelow Vetter and von Briesen. There's no daylight between Matt Chason and MPS. So keep that in mind. That's what they've done, and so the point is that it's all coordinated. That's what the point is. So on October 18th of this year, Saveon Grinnell and Mark Olsen filed a motion to quash. We asked for Mr. Chason's records, and they said we shouldn't get them. And they say that this requires, they just say it's not there's no indication whether the information sought is relevant. Okay. So we won that one pretty clearly. Then it says there are no specific topics sought in relation to the documents, and nor are there any restrictions on the time frame for the information sought. Okay. That argument, I think, was somewhat successful with the judge. She cabined the time frame to a smaller degree than we had originally asked for. I think we did 5 years. All right, next they ordered that the information may be protected by attorney-client privilege and attorney work product. Well, that was the most baffling of all to me because we're talking about Mr. Chason's personal notes from a time period before Saveon Grinnell was hired by them, or indeed that he was he denies actively working with the city attorney's office under oath. So that is a surprising assertion. But hey, we all have jobs to do. So then they argued that it was unreasonable and impressive without stating why. And then stating that we couldn't, because as she ordered in Dr. Garcia-Hoven's case, that we should go through MPS to ask for MPS's records. Well, we had already established, both from emails from Mr. Chason and Mr. Chason's testimony, that he, in fact, had separate offline documents and a whole separate offline record system for his office that he maintained using his Roadrunner and other accounts outside of the MPS record retention system, and that he had not provided those documents to MPS at any time, nor had they asked him for them, is what I recall. So, well, what happened next? On November 29th, we have to keep this in mind that the hearing for this case during this time was set for December 22nd, 3 weeks prior to the hearing, that we had scheduled in June. Judge Brown makes the following ruling. Mr. Chason's motion to quash is denied. Mr. Chason is ordered to produce his personal notes, objects, logs, letters, documents, phone logs, messages, or any personal information in his sole possession or sole control for the period of January 2nd, 2020 to present, related to complaints made with the Office of Accountability and Efficiency by Deborah Kuether, Dr. Bowling, Angela Ford, Teresa Falderon, Jose Garcia-Hoven, Calvin Fermin, Amy Chastik, Keith Posley, Rashinda Kantosh, and Marla Brunei. Mr. Chason is ordered to produce these documents to the complainant's attorney by December 16th of 2022. So she gave him 17 days to produce these documents. Mr. Chason is also required to produce all emails sent from mchason@wi.rr.com or received at mchason@wi.rr.com from the period January 2nd, 2020 to the present that relates to Dr. Kuether. Mr. Chason is ordered to produce those documents to the complainant's attorney by December 16th, 2020. Now here's the kicker. I recognize that receiving these documents on or before December 16th will not provide the complainant sufficient time to prepare for the December hearing. I am also aware that the parties have motions to compel pending. If I grant those motions, the parties will not have adequate time to prepare for the hearing. Therefore, I am postponing the hearing scheduled for December 19th through December 22nd to sometime in 2023. I will provide you with new dates. I am available for hearing soon. Well, we don't have those dates now, just so we're clear on that. We have asked MPS to give us dates for Dr. Kuether. We don't have any dates for that. They just don't respond on that particular issue. So that was pretty frustrating. So the hearing is postponed, apparently indefinitely. We don't know what's going on there. But at the same time, we're ordered to get these documents that we have been trying to get since January of this year. So you win some, you lose some, I guess. Never mind that, my whole schedule, Dr. Kuether's whole schedule, really our whole life is just on hold now. Her whole life, I guess, is just on hold now, waiting for her day in court once again. So, hey, I guess that's how it goes. Whoops, they failed to give us documents. They needed more time. They couldn't get it to them because they made a bunch of reasons. I mean, again, these arguments had already been rejected, I believe, in May. They made the same ones again. And what did they get out of it? Well, they got a new hearing date. So that's at least one good thing for them. Now, Saveon Grinnell, Mark Olsen, and I conferred because, hey, our first thought was maybe we'll get this hearing going, and we were ready to go. We didn't need this to hold everything up. So we wanted to figure out what exactly they had and go from there. So what do? I say, look, gentlemen, I will come out to you. We'll discuss this. We'll figure out what you have. We'll figure out what I want. And if we can ease the burden on you, let's do that. Because that's what you do. So I drove out there, and we had one of those meetings. They postured. I postured. That's how we go. I do believe that Saveon Grinnell quoted P.G. Woodhouse back to me, but I can't confirm if he's an avid Woodhouse fan like me or not, or if he just remembers me saying that at one time. But I will keep that in mind for future reference. My point here is this, that we had a very frank discussion about what it is that we wanted and what I saw as their problem. So they needed to produce these documents. They're not ready to produce these documents. Apparently it was just too rushed. They couldn't possibly do it. It was thousands of documents. Of course, they'd had a subpoena since mid-October. At the latest, and they filed their motion to quash, and they finally got their answer, and then all of a sudden they're scrambling here. Well, okay, that's on you, I guess, but here we are. So we go and we meet with them, and there's a couple of things we need to be clear on. So I say, look, gentlemen, I want certain documents immediately by that deadline. I understand there's emails that you've got to go through. I understand you've got to look at all of them, make sure. That's what I would have to do. No question about it. I have no idea how many emails they were at that point. I don't think they had any idea of how many emails we're talking about. It's a significant amount. I don't dispute that. But we more or less came to some sort of agreement where they could produce these specific documents that we wanted, which were related to Keith Posley and Marla Brunei, through this period in question here. And there's something. They really are something. But what we got was redacted documents. I mean, you better believe it. So what does that mean? That means that they went through these documents and covered up things that they didn't think that we should have. We'll just look at some. Hold on a second. So this is page 1. We'll have to get a document, can't we? So here's page 2. You can see who knows what's behind the black box there. It's page 3. Page 4. There's some information there, but others, we only get to see what Saveon Grinnell thinks that we get to see. All right. Here's one thing that we found out that we didn't have before. We'll get into this in much greater detail, but I think it's worth noting here because we did fight 9 months for this. This is Mr. Chason saying, "The one and only time that I shared with the board a concern intersecting with Chief Brunei, Dr. Posley called me and shared that he wanted me to issue a retraction of that communication to the board. And when I refused, his personal attorney called me on my personal cell phone to challenge my obligation to keep you, the board, informed. If history is any indicator, he may do the same again in response to my meeting obligations to you tonight." Okay? He told the board this. And I think we're all clear on what they've done to resolve that issue here. So, now, let's just get on to how you respond to redactions. So, I email Mr. Grinnell and say, "Hey, Saveon." And that's when 2 attorneys are talking to each other. I believe it's the proper protocol to, because we're all sibling attorneys here. I think we used to say brother attorneys, that we address each other. It's proper to address each other by our first names because that's familiar. Now, otherwise, I would address him as Mr. Grinnell if we were in court or otherwise in a public setting. But because I'm reading you these emails here, that's how I write. So, Saveon, there are redactions in the document you produced. Who created these documents? Question mark. Send the unredacted documents immediately. Ben. So, Saveon responds, and this is December 22nd here. Ben, I created the redactions and will not be sending unredacted copies. They contain attorney-client privileged information and personally identifiable information to which you are not entitled to, including third-party whistleblower information unrelated to this matter. Where did we hear that before? Oh, yeah, that was Jill Hall. Ryan Maloney and Von Briesen made that argument the first time. Right. So straight from their lips to Judge Brown, who did not find that at all persuasive the first time. Then Saveon Grinnell didn't put that in his argument, in his motion to quash. He put attorney-client privilege in there. Where did that get him? Didn't get him anywhere. Nope, she did not make she did not go for that argument. Personally identifiable information, of course. Lots of things personally identify from people. Let's think about all of these documents that they sent us with everybody's email. So obviously that's, you can say that. It's just not compelling because based on your previous behavior, but also because of the law. So the law says that you don't get to choose, you can't just redact things that are in discovery. That's how it goes. You may want to people from embarrassment, then what do? You file a motion for a protective order. That's what they did. And it wasn't granted. It was denied. We saw that. Mr. Chason's motion to quash is denied. Many people, many attorneys would respond to that by complying with the judge's order. Others don't. All right, moving on. He says, additionally, the phone logs are Mr. Chason's family phone bill account and contain numbers and communication his family has made. There is a privacy interest in redacting that information. The information relevant is still available for viewing. I mean, isn't that awesome? Don't you appreciate that? That MPS is going to give us what they feel we should have? Shouldn't we be thankful for that? I won't belittle it by calling it a Christmas miracle, but, I think what that shows is the attitude there of one rule for the employer and another rule for the employee, which is the law in many cases, but not here, not for discovery. That rule is the same for everybody, and we're going to have it. So we'll see how that goes. So moving on, he says, thanks, Saveon. And, okay. So I then say to Saveon, right, you already asked for a protective order which was denied, and now you have delayed the hearing and cost my client significant damages and fees. Your third-party whistleblower nonsense was already raised by your confederates Jill Hall and Ryan Maloney before they hired you and was already rejected. Please explain why you should not be liable for these expenses and fees. You admitted violating Judge Brown's decision. Yours, Ben. Oh, just one more thing to back up. So the last thing that we had in this meeting of ours, when I went all the way down to Brookfield and talked to Saveon Grinnell and Mark Olsen, was Mark Olsen. By the way, his son was on my football team at Fancy Kids School. So that's just in case you think this is a big town, or you think even big world or universe, really. Facts speak otherwise, but also, we're all connected, no doubt about it. Well, some people that matters and some people it doesn't, okay? So there we are with that one. Well, Mark Olsen said, looked me straight in the eye, and he told me, Ben, you can trust us. What else does one do but laugh? I mean, is there any other proper response? That's what I did. That's my recollection. I laughed because, hey. And where are we now? Right. It's that's where we are. So, these kind of redactions make the FBI of the J. Edgar Hoover look like a public records activist here. I mean, at least this is the big distinction here between Buelow Vetter and Saveon Grinnell and Mark Olsen and what Chris Reardon and Ryan Maloney and Jill Hall at Von Briesen are doing. So at least they gave us this blank page here that shows that there's information that they chose that they're saying we're not going to give you. It's against the judge ordered them to give it to us, but they're just not doing it. Okay. But as opposed to, this is the Jill Hall, Ryan Maloney, Chris Reardon answer here is, not just bearing it in this, it's not there. There's no redactions or anything, it's just not there. So that's I think the key thing to keep, compare and contrast, to give credit where credit is due, okay. And Ryan Maloney doesn't look like, Chris Reardon doesn't look like J. Edgar Hoover, but at the same time, now they've been caught because somebody has to have these documents. Somebody. So, okay. Now, What does Saveon Grinnell say in response to the fact that he already asked for a protective order and it was already denied and he's in violating the court's order and he was required to produce everything by the 18th? Because I demanded everything now. We had an agreement to propose to have documents. As I said, I went there and conferred with them, and I explained to them that that agreement was now off because they didn't hold up their end of the bargain by redacting. So, Saveon says, Ben, I will not be explaining anything to you, as that won't get us anywhere, I'm afraid. Kindly forward what protective order was denied in a paragraph in her most recent order you believe were violated. As you know, because of you asking for the documents related to 10 different people for almost a 3-year time period, that may take some time to produce. So as you can imagine, it's no surprise that the ALJs postpone the hearing until you can get the documents you so desperately need. Now, if I must wait until Mr. Chason can produce all these documents to us, then review them and file a protective order with Judge Brown about redaction / withholdings we believe are necessary, then I will do so. If you have a quicker solution, I am all ears. Best, Saveon. Hey. Once again, we got to do the work. They just don't do it. They just don't do it. They just don't do it. And we got to clean up their mess. You know? These are people who are used to having engineers around, who are used to having cleaners around, who are used to having staff available to them to clean up their messes. Well, I'm not on their staff. And when they make these, there's a consequence for these kind of messes, and I think they need to pay for it. And we already filed a motion with Judge Brown, as we'll get into, because this is completely unacceptable. And their answer was, well, you got to make us, it's up to you to show us why we can't do whatever, defy the order. And when we're ordered to produce documents, then we can just redact them. It's up to you to show us why we can't redact them. Okay. So I responded, that dog won't hunt. We don't have to wait. We have the order. You were ordered to produce these documents by the 18th and defied the order. We already moved for sanctions, including fees, cost, and default judgment against Chason and MPS. As Mark said, you can trust us, Ben. So what does default judgment mean? Well, if you guys remember the Sandy Hook guy who was what is that called? Alex Jones. All right. If you remember the Alex Jones case, he refused to respond to discovery about his actions regarding Sandy Hook and his coverage of that case and his apparently defamatory statements. Okay, well, what happened to him? He got default judgment rendered against him. That's the rule. If you don't participate in discovery and you refuse to produce discovery as a complainant, as the employee, you can have the case dismissed, and they will dismiss the case. Well, as the employer, the same thing is also true. Of course, it happens way less often because the employee is really usually not in a position to force that. But here we are, and we've asked for the case against MPS to be found liable by default for discriminating against Dr. Kuether because they have and continue to withhold documents. We've asserted that Mr. Chason is acting on behalf of MPS and withholding documents. We've also asserted because these documents were available to MPS because he clearly gave them to them, that because they didn't produce them, they have withheld documents, and therefore they need default judgment to be entered against them. So let's just be clear, the attitude here, and I think this is about all we need to say about Saveon Grinnell and Mark Olsen and how they feel about the laws of the state of Wisconsin. So he responds on December 22nd, 12/24, and says, right, .. Anywho, We will get you the other documents as they become available to us. Happy holidays, Saveon. Well, there you have it. So, one rule for the employer, another rule for the employee. Well, we'll see what happens, and we will definitely keep you posted. But just so you know, this is another example of the kind of tricks that they're playing. I think it's fairly clear that what's going on here is that they are trying to protect somebody. These documents are shielding somebody. And they're not worried about privacy. They're certainly not worried about anything else. I think this comment that I read out here before, I think says everything about who they are working for. And when I refused, his personal attorney called me on my personal cell phone to challenge my obligation to keep you, the board, informed. Yes. Well, that's the update for today. Happy holidays, Merry Christmas, Happy Hanukkah to everybody, and all the best. We appreciate all your views, all your interest. If you like this video, if you like any of our other videos, we appreciate if you like them, if you get value out of them, please indicate that. Comments are always helpful, and I know that many of you, more of you, would love to comment than are able to. But if you find a way that you feel to be sufficiently anonymous, we certainly would appreciate your comments and feedback, even if it's just a like. It really means a lot to us and helps us know that we're moving in the right direction. So thank you very much. Have a great day.